alleged there, including murder, grave violence, and destruction of homes and property, were criminal offenses which the trial chamber there found could not be adequately handled internally by the Ministry of Interior as an internal disciplinary breach. And I cite that trial chamber decision at 521. I think it's important for the chamber to hear specifics about the Boshkovsky trial judgment and appeals judgment because it's so similar to the case that we are dealing with respect to General Markač. And I'm talking about specifically paragraphs 523 to 526 of the trial judgment. The evidence presented indicate in the Boshkovsky case that he was present as Minister of Interior for over an hour at a house while 10 ethnic Albanians were being held there, guarded by police. The prisoners were lying face down with their heads covered. Boshkovsky was told they were terrorists who had been captured. While he was in the village, he heard firing and could see houses burning. Even though the chamber, in that case, established from the evidence presented that the men being held had been severely beaten prior to the time Boshkovsky had seen them, they could not conclude from the evidence that Boshkovsky witnessed any mistreatment or, quote, should have deduced from the appearance of the 10 that there had been criminal mistreatment, end quote. Similarly, even though homes were burning, the chamber concluded that no evidence presented proved that Boshkovsky should have known that there was arson or wanton destruction of property. The chamber found that he had been supplied an explanation by the police that there had been an armed conflict between the security forces and terrorists, coupled with the testimony that he had been shown 3 firearms and ammunition that he was told were seized from the terrorists, and that was sufficient to support Boshkovsky's understanding of the events. The trial chamber found no evidence that Boshkovsky saw or was told of any person being shot or killed while visiting the village. In affirming the acquittal, the appeals chamber stated that the information in possession of the civilian police was determined in the ordinary course to have led an investigative judge and the public prosecutor to conduct a proper investigation as anticipated by the law in such circumstances. Though evidence presented did not confirm that Boshkovsky had ordered the notification to the criminal police, the record indicated that members of police officers in his ministry passed the relevant information on to competent authorities. That's at paragraph 267. The similarity between the Boshkovsky case and the case facing General Markač is striking. One important difference, General Markač was never in Grubry. General Markač never saw with his own eyes what happened there. General Markač learned everything about Grubry from written reports from subordinates who were either on the scene or who participated in the action. Those written reports talked about armed conflict. Let's look at reasonableness from General Markač's standpoint with respect to Grubry. He gets notice the evening of August 25th that something happened in an area where his forces were operating. He sends his chief of staff, Željko Sačić, to find out more information. The same day he gets this information. The next day his chief of staff sets out for Knin, and he finds out from his chief of staff that there are dead bodies and that there are police on the scene. Now, if a crime occurred, it is the competence of the MUK criminal police to investigate it. If the deaths were not in fact the result of lawful armed conflict, they had a legal obligation to investigate. All the information in General Markač's possession is relayed to him by others. Even Bashkowski, who is on the scene seeing the burning, is not held criminally responsible for failing to act. Unless General Markač has information which has been provided to him which is to the contrary, there is no reason for him not to believe what he's learned from his subordinates. In addition, Witness 86 and Witness Buhin were waiting for instructions from Ivica Cetina, the head of the Zadar Crime Police, under whose jurisdiction any criminal investigation fell. This is Witness 86's testimony at transcript 5292. Paragraph 433 of the prosecution's brief. Even where the prosecutor admits that Markač initiated investigative efforts commensurate with his resources and authority, the prosecutor attributes ungrounded nefarious motives to these efforts. Paragraph 434 alleges that Markač had a discussion with Čermák about what Čermák would say to UN TV. This is undocumented, unsubstantiated, and non-existent. There is no factual reference that General Markač talked to General Čermák about anything related to Grubry other than the initial notice that something happened on August 25th. This is an effort to construct an agreement between Čermák and Markač to mislead regarding the events of the day. Paragraph 439. Almost every act in this paragraph is alleged to be independent of anything Markač did. This and subsequent paragraphs paint the picture that Željko Sačić could sow fear and independently wield enough influence to cow witnesses 84, 86, an entire office of police authorities, as well as Čermák, Morić, Jarnjak, Cetina, and Buhin. Paragraphs 442 and 443. At this point in the brief, as to Markač's own actions, it appears the prosecutor would have it both ways. In this unbelievable account, he has failed to personally intervene and criminally absented himself from supervising his subordinates, while simultaneously encouraging and soliciting them to commit crimes while present at the scene of the events. It ignores the reality that the undisputed evidence is from August 8th to the 21st. The Special Police were not operating in Sector South beyond their remit. It is difficult to conjure a vision of command more divorced from the realities and challenges of combat leadership. This discussion, it completely ignores the chain of command and merely equates Markač's position as being an impetus for culpability. In essence, the argument both in the brief and during oral argument is that a unit of the Special Police went into Grubry on August 25th, 1995 in a mop-up operation and following Markač's orders murdered 5 civilians. Markač knew that the Lučko unit was involved. He knew that some or all of its members committed murder, and he didn't punish them for it. He then covered it up, and he knew it all by 5 o'clock in the evening on August 25th, 1995. That's the prosecution's view. That's the simple view. In my opinion, that's the warped view, the completely wrong view, which leads to conclusions justified by unsubstantiated assumptions. Justice is supposed to be blind, but this method of argument by the OTP is an attempt to circumvent justice. Markač is presumed to have criminal culpability through conclusory statements without an analysis of the evidence as applied to the law. Prosecution has argued throughout this case that the Internal Control Department is a means of discipline for the Special Police. It's wrong. I'll refer you to Janich's trial testimony 6199 to 200, where he discusses that they did intelligence analysis and security assessments, among other things. General Markač can act on information that's only as good as the source, and the source for his information are his subordinates. To be blunt, if he's being lied to, misled, misinformed, deliberately or due to the incompetence or human failings of others, he cannot be blamed for passing on information that he gets from those who were either on the ground, asked to look into the matter, or who didn't have the guts to tell the truth back in 1995. The multiple investigations undertaken by the Croatian State Attorney's Office in Gruberi, one in 2001 by Mr. Željko Žganjer, and the second one, which is still ongoing, by Mladen Bajic, right as the Markač defense was in the middle of its case in chief, have done nothing to clarify what happened there, but significantly have not produced any evidence that at the time of the events, General Markač knew that members of the Special Police committed murder of civilians on August 25, 1995. Žganjer said that he found no evidence in 2001 that General Markač had done anything to cover up the events in Gruberi, nor that he either influenced anyone else during the relevant time period. If he had, he would have been obligated to pursue charges. That's what he said himself at transcript reference 11609.